Hello, guys. So today we're talking about addendums in the legal world. An addendum is a supplementary document. You can see it's gotten from the word adding something. So an addendum has to do with an additional document. So it's not a standalone document. It is a document that exists because there's another original one that came prior to the addendum. And the purpose is either to alter the provisions of the existing document or to modify it, and it will become binding just as the existing document has been binding. And the addendum is equally binding as long as it has been signed by all the parties to the original document. So basically, the essence of an addendum is to save the parties from having to draft up a new document. Usually, they're talking about agreements or contracts. So the addendum saves the parties from drafting an entirely new document. Rather, you go through the use of an addendum, and the addendum helps you to make those updates that you intend to make with that document, with that contract or agreement. So that's the essence of an addendum. From this definition, we can adduce the nature of an addendum. So the nature of an addendum is that it is not a standalone document. So once you hear that there's an addendum, once you see any document that has the title an addendum, then you know that there's an existing document that the addendum has come to update. So an addendum is not a standalone document. That's the first nature. The second nature or feature of an addendum is that it does not discard the existing document. Rather, an addendum serves to update the terms of the existing document. It can only alter some of the provisions of the initial agreement, or it can modify them, clarifying them. There are some, because some provisions may not be clear and maybe would have caused some issues in the course of implementing that initial contract. And so where this kind of thing happens and there has been an issue with respect to understanding or carrying out the terms of the contract or the agreement, then an addendum can serve to explain it further, give very detailed explanation and clarification as to what that provision states. So an addendum does not discard the existing principal document or contract. Rather, it serves to update the terms or modify those terms, alter them, or nullify some provisions based on the parties' agreement. The third nature or feature of an addendum is that once the addendum has been executed by all the parties to the initial document, to the initial agreement, the addendum becomes binding on all parties and will be read alongside that principal document. So the implication is that once you see an addendum, you're supposed to read it alongside the existing document. This is important because let's look at an example where, let's say, clause 4 of the principal contract gives a condition and gives a time frame of 1 month, and in the addendum they want to change that time frame of 1 month to 3 months, and you're looking at clause 4 of that initial agreement. If you don't read the initial agreement alongside the addendum, you will go with the wrong notion that clause 4 provides for 1 month. Meanwhile, in the addendum, it has clarified that that clause 4 of the principal agreement should be read as 3 months. So this is why this particular nature of an addendum is very important, that the addendum will be read alongside the principal document once it has been validly executed by all the parties. We will now look at the legal requirements with respect to an addendum in Nigeria. Now, the first requirement for an addendum to be legally binding in Nigeria is that there must be a consensus addendum. Consensus addendum just means the parties must all agree. Like I stated during the definition, The parties to the existing contract must all agree and sign the addendum for it to be binding. This goes without saying, because since an addendum is a supplement to the existing document or the principal document, all the parties that signed the principal document must also agree and sign the addendum. So there must be an agreement between all the parties involved. The second legal requirement with respect to addendums to make sure that an addendum is valid in Nigeria has to do with the execution of the addendum. Executing a document means signing a document. So an execution is what makes an agreement or a document binding, because it shows that the parties agreed to those conditions as set forth in that document. And so, for instance, if the existing or principal agreement was executed under seal, then the addendum must also be executed under seal. So essentially, again, what all the conditions that were observed with respect to the prior or principal agreement, all those conditions have to be followed with respect to the addendum. So a document under seal that is signed, sealed, and delivered will have, the addendum also has to follow that same format. But if the document was just executed, the same execution format with the principal document is the same execution format that should be applied to the addendum. The third legal requirement with respect to addendums in Nigeria is consideration. And consideration in a contract simply means the amount that will be paid by the parties. So if somebody is offering goods or services, another party is accepting and paying money for the goods or services that are being offered. Consideration can also be in kind. This means that the other party may also be required to return a favor or return an obligation that is not necessarily cash. So, but as long as the parties have agreed that that's the consideration, then it stands. So the important thing is that for a contract to be binding, there must be consideration, and the consideration doesn't have to be adequate. As long as there's consideration, it is binding. So that is it with respect to contracts. So now, with respect to addendums, considerations may not be required since the addendum is not a fresh new agreement. So looking at the nature of an addendum, like I've said repeatedly, an addendum just serves the purposes of updating the terms of an existing contract. So since the addendum just updates some terms, clarifies some terms, there may not be need for consideration. However, the need for consideration may arise in an addendum if the provisions of the addendum significantly modifies the obligations of the parties, such that consideration is now required for the updated obligations. So the take home here is that consideration may not be required in an addendum, just as it is with a contract. The final legal requirement with respect to addendums that I'll be talking about is the requirement for stamping or registration. Now, stamping has to do with stamp duties that will be paid to the tax authorities, and registration has to do with the perfection of documents. So if the initial contract has to do with its documents that need to be stamped or registered at the appropriate authorities, then the addendum will similarly follow that line, because the addendum also required to be stamped and registered accordingly, since it's an alteration to the terms. So the updated terms have to be stamped and registered accordingly if the original contract was stamped and registered. We will now be looking at the common uses of addendums in Nigeria. The first common use of addendums in Nigeria is with respect to real estate transactions. Real estate transactions are one common aspect where addendums are used in Nigeria. Particularly, it can be used to modify the terms of a lease, and usually it's for long leases. So let's imagine a 20-year lease or a 30-year lease. You can see that these are long-term leases, and in the course of these long-term leases, there will definitely be need to adjust the rent that is paid by the lessee, that's the tenant. So instead of drafting a new lease agreement, the parties can draft an addendum just to cater for the rent that will be paid by the lessee. You can also use the addendum to extend the duration of the lease. If the 20-year lease, the 20-year period is coming to an end, you can still lease it for 5 years. So let's assume that the 5-year lease is coming to an end, and the lessor doesn't mind increasing the lease term for another 5 years. Instead of drafting a new lease agreement, the parties can draft an addendum just to increase the term for another 5 years. So these are instances in real estate transactions that addendums are used. The third instance in which addendums are commonly used in Nigeria is with respect to employment contracts. Now, the same thing applies in the sense that an employment contract for an employee that has stayed for a long time, and you just want to vary some provisions of the employee's contract. You don't have to redraft and execute an entirely new contract. The employer can just use an addendum to modify or update the terms of the employee's contract. Employment contracts are another avenue that addendums are commonly used in Nigeria. The final area that we'll be looking at in this video with respect to common uses of addendums in Nigeria is with respect to commercial transactions generally. So with respect to commercial transactions, addendums can be used to adjust payment terms, the terms and conditions with respect to payment. For instance, you want to alter the time in which payments will be made. The initial contract can state that payment must be made within 14 days of the delivery of the goods. And with practical experience, it's seen that 14 days is too small to meet up with that kind of transaction. So an addendum can be drawn up to adjust that date. Maybe can now say, okay, 21 days is more realistic for the parties. So you use it to adjust the payment terms, or you can also use it to adjust delivery schedules. Another instance of altering commercial transactions in which addendums are required is with respect to the warranties in supply contracts. So you can also use an addendum to modify the warranty terms and conditions with respect to supply contracts or wherever warranties are required. These basically are the most common forms and uses of addendums in Nigeria. And from these instances, you can see how relevant the use of addendums are in the business world, because it saves the parties lots of time and effort in having to go through the entire contract. Before we conclude, it is important to draw a distinction between an amendment and an addendum. So an amendment, as the name implies, basically amends the provisions of a contract. It's not a standalone document. You will recall that at the beginning of this video, one of the features of an addendum is that it's a standalone document. So there's a principal document, and then an addendum is a standalone document. But an amendment merely modifies the provisions within the same document or contract, while an addendum is a standalone document that seeks to update the terms of an existing document. So an addendum and amendment are related concepts, but they are not basically the same concept. Another related concept to an addendum is a supplementary agreement. This is also different from an amendment, which we had looked at as a related concept. So with respect to a supplementary agreement, it is actually more similar to an addendum. However, a supplementary agreement serves the purpose of a fresh document. So this is unlike an addendum that is not a fresh contract. It's not an entirely new document, but a supplementary agreement is a new document. So a supplementary agreement looks like an addendum, but it is not a standalone per se, just like an addendum. In conclusion, the use of an addendum is a pragmatic tool for contract management. This means that the use of an addendum helps to provide for efficiency with respect to managing contracts, that is, managing existing contracts. So addendums allow parties to adjust to new realities rather than get stuck with the old agreement, with the old terms of contracts that are not pragmatic, that are not feasible. So addendums allow parties to adjust to new realities without having to discard their initial agreements, and it enables parties to adjust to current realities that are more practical and are more feasible based on current realities. This is why we'll be drawing the curtain with respect to this video and with respect to addendums. I hope you got value for it. Please kindly comment in the comment section below, make your observations or ask your questions in the comment section below. Also, please do well to like the video, and please also subscribe to the channel so that you'll get updates as we upload new videos. Thank you for staying up to this point. I'll see you in my next video. Bye.